I just received this from Tim Robinson. He sent it to me. It's from Newsweek. The court ruled that the AR-15, a high-powered rifle used in a Parkland shooting, and other similar military-style rifles in high capacity are not protected under the Second Amendment. Well, number one, well, actually, there's two things that are wrong with this judge. And they are beyond the scope of the Second Amendment and may be banned, wrote Massachusetts District Court Judge William Young. Okay? He must be a real doozy. Number one, he doesn't understand the Constitution, and yet he's a judge. This guy didn't study the Constitution. He only studied what other judges said about it. Remember that. I'll put a link into this thing because I won't read it all, but I'll get down here to the bottom. Let's see. Yeah, Young cited several prominent cases in the decision, most notably the landmark 2020 and 2008 Supreme Court case, District of Columbia versus Heller. And this is about a handgun. The case upheld individuals could own firearms, but noted several limitations to the Second Amendment. And those limitations were like a machine gun or trying to carry a cannon underneath your arm. That's what that meant, not the way this guy interpreted it. He said, explained these weapons are mostly used in military service. M16 rifles and the like are not protected under the Second Amendment. You're wrong, Buckwheat. Here's the reason why. Back in 1775, the weapon used during that time was the same one that the other military had, which makes it legal. Now, here's what gets me. Well, maybe this is big enough I don't have to zoom this for you guys. This is the AR-15 and the M16 were designed and manufactured simultaneously for the military and share very similar features and function, Young wrote. Now, I'll read that again. The AR-15 and M16 were designed and manufactured simultaneously for the military and share very similar features and functions. Wrong. Eugene Stoner invented the M16. It was select fire. You could with the selector switch, you could shoot semi-auto, and you flip it the other way, it goes full auto. The M16 and the AR-15 are totally different creatures. The AR-15 is only semi-auto only, which makes it legal. Oh, these guys, yeah, don't get excited about this ruling. I'm sure real quick this is going to get overturned because this guy's he's a nitwit. Yet the AR-15's present-day popularity is not constitutionally material. The test is not the AR's present-day popularity, but whether it is a weapon most useful in military service. What the hell is this guy talking about? He says, yeah, Justice Scalia would be proud. No, he wouldn't. You're a effing idiot. You don't know the Constitution. You don't know nothing about the background of the militia. I don't think you know much about anything, except I get a paycheck every once in a while, man. I'm cool. Yeah. Well, anyway, guys, this is what was in, this was for, I'll get the date up here. Well, I don't want to see you. It's 4/6. Excuse me. Get this thing zoomed up here. 4/6/18 at 2:10. And I want to thank Tim Robinson for getting that out here. Like I said, I'll put a link down here. You guys can read this yourself. But don't get all bent out of shape over it because, like I said, this federal court, this judge, this nitwit, He ain't nobody to worry about. Yep. I'm gonna make sure I get his name down here. Massachusetts District Court Judge William Young. What the heck is this non-profit group? Oh, Gun Owners. Okay, non-profit Gunners of American League. Okay, that's a good one. Okay, I'll get this thing clicked for the. So you got the link, and then you can go watch this. Thanks for watching. Oh, Tim Robinson. Thanks, buddy.